Springfield of Surrey County Council against YXA, Respondent, and Wolverhampton City Council against YXA.
Lord Fawkes.
My Lords, I appear for the appellant together with my learned friend Mr. Stagg, who sits next to me, and my learned friend Mr. Jones, who sits behind me. We're for the appellants in both cases, and the respondents are both represented by Miss Lizanne Cumble, KC, and Justin Levinson. My Lords, may I begin by dealing with the question of anonymity? We cover this in our written case. Orders for anonymity were made below. YXA has a statutory right for anonymity as a victim of sexual abuse, and YXA is vulnerable because of his disabilities, and the official solicitor has acted at all times as a litigation friend, so I would ask that the anonymity order be continued.
Yes, and I imagine that's uncontroversial. Yes, certainly, we'll continue the order.
My Lords, the issue in both cases is in what circumstances does a local authority, in its social services capacity, owe a duty of care actionable at the suit, usually of a child, but to anyone potentially affected by their acts or omissions. My Lords, there's been a considerable amount of judicial activity in this area of the law. The first case in which the question was considered at House of Lords level was now 28 years ago in X and Bedfordshire, a case that I understand has stretched the intellectual powers of many law students. There have been many cases in the appellate courts since, some specifically dealing with the question of liability of social workers, others concerning different local authorities, such as highway authorities or local education authorities. And of relevance too to the analysis of whether a duty is owed is the position of the police and the other emergency services. Over the years, various dividing lines as to when a duty might or might not exist have come in and gone out of favour. The distinction between policy and operational, for one, and between acts and omissions, and the role of policy in the analysis. These tests have been examined and either rejected or considerably refined by the courts. There is even a hint in the judgment of Lord Justice Baker of a further distinction between general and specific duties. Here, my Lords, the issue is, did on the assumed facts the local authority, and more specifically social workers, arguably assume responsibility to the claimants? Now, the answer to that question was given in the negative by Deputy Master Baggott, KC, Master Dagnall, and Mrs. Justice Stacey on appeal from those decisions. And I commend all those careful and thorough judgments to your Lordships. Between the hearings before the Masters and the appeal to Mrs. Justice Stacey, there was a full-scale trial in the case of DFX versus Coventry, conducted before Mrs. Justice Lambert, in a case with close parallels to those before the court here. And her analysis was referred to with approval by Mrs. Justice Stacey in her judgment. After what was a lengthy and expensive trial, Mrs. Justice Lambert decided that on the facts no duty was owed, but that in any event there was no breach of a putative duty. So in a sense, the expense and general diversion of resources was unnecessary. And I commend the judgment too to your Lordships in DFX. No one could pretend that this was a straightforward area of the law, but her analysis, we submit at first instance, represents a valuable contribution to the jurisprudence in this area. In essence, all the judges I've referred to applied the decision of this court in N versus Poole to the different factual scenarios, and it would be our submission that they were right to do so. The Court of Appeal, however, came to a different conclusion. In essence, the court, and it was Lord Justice Baker who gave the only judgment, decided that some aspects of the intervention of social workers might, at trial, be considered to amount to an assumption of responsibility. In YXA, what was identified as potentially giving rise to an assumption of responsibility was resolving to seek legal advice with a vision to commencing care proceedings and arranging for so-called keeping safe work. And in YXA, the Section 20 accommodation was held arguably to be an assumption of responsibility, and it was not limited to the period when the child was actually temporarily accommodated. So the Court of Appeal said that the law would become clearer in due course. But if the Court of Appeal is right, then these cases and many others will have to go to trial, and it's only then, apparently, that the law should become clearer. And there are, my lords, a lot of cases waiting in the wings. And if I may, I'd like to refer the Court to two statements. Firstly, of Mark Whitaker, which can be found at EF 314. He's a partner in the firm of DWF LLP, who has conduct to this claim and has enormous experience in this area of the law. I won't, of course, read out the statement, but perhaps I can just highlight one or two paragraphs which may help. In paragraph 6, he says, I've been advised that Zurich, who are probably the main insurer, has 492 claims on its book. If one assumes that it's representative of other insurers, and bearing in mind that Zurich has about 40% of the market share, it's reasonable to estimate there in excess of 1,000 notified failure to remove claims pending against local authorities against England and Wales. Paragraph 8, the inevitable result of the Court of Appeal decision in this case is that local authorities will not generally be able to strike out claims. They will either have to be settled cases or likely contested through to trial. And then paragraph 10, the legal costs are invariably far higher than the usual range of awards. Investigations into potential liability typically involve a review of a huge volume of social services records and educational records. Witnesses need to be traced and interviewed on matters dating back many years. Social services experts need to be instructed on the question of breach of duty, and these experts will be required to carry out a detailed trawl through the records. Additionally, medical experts need to be instructed to consider causation. The next paragraph, he deals with the huge expense that was involved in DFX, the case tried by Mrs. Justice Lambert. There were 14 expert witnesses instructed to produce reports, and the costs were approximately £1 million, none of which was recoverable for the claimant. He does say that it's probable that the complex medical issues made this exceptional, but nevertheless, as he concludes in paragraph 12, the combined costs of between £300,000 and £500,000 are a reasonable estimation of what might be involved in taking these cases to trial. Similarly, there is a statement from Louise Marie Fisher, which is at EF 834. It's the core volume YXA appeal. She covers much the same ground, and I won't read out what she says, except perhaps to refer to paragraph 7, where she says, I'm informed by counsel and believe that in another case in which he acts is currently pending. A solicitor who acts for the claimants in this case has stated the official solicitor who acts as litigation friend for the claimants in that case, the claimant in this case, is performing a role in 476 live claims under the Human Rights Act and approximately 1,600 civil claims which are described as similar matters. In my experience, the official solicitor does act for a number of substantial numbers of claimants in these matters, but many claims do not have the involvement from the official solicitor. So I think the court will get an idea of the range of these cases and the number of them and the potential expense. Now that, of course, of itself there's no reason why the law should not recognise a duty of care if it is appropriate to do so. But our submission is that the law is clear. The decision in N versus Poole, only 4 years ago, together with the decisions in Michael and Robinson, both at Supreme Court level, amount to a cogent and intellectually clear body of law in this area. And it is, my lords, of significance that the 4 judges I've identified before the Court of Appeal were able to apply the law before the Court of Appeal concluded as it did. My lords, in considering this matter, it may be helpful to ask ourselves what social workers actually do. Although it is reasonably well known, their duties, and we set this out in some detail in our printed case, are provided by statute and by guidance. And may I take the court to our printed case, and in particular to page 98, EF 983. It's in the core volume documents relevant to both appeals, the slim volume which contains both of our printed cases. We there set out the statutory scheme, and may I just highlight 1 or 2 points from that. Paragraph 22, EF 984, we refer to the fact that Part 3 of the 1989 Children Act relates to the provision of services for children in need. There is a general duty to safeguard and promote the welfare of such children by providing a range and level of services appropriate to those children's needs. Specific duties and powers are set out facilitating the discharge of the general duty, including taking reasonable steps to prevent children suffering ill treatment or neglect, and to reduce the need to bring proceedings for care orders. That last sentence is of some significance. And then the next paragraph, a local authority is obliged to provide accommodation for a child if a person caring for him is prevented, whether or not permanently, and for whatever reason, from providing him with suitable accommodation or care. There is also power to provide accommodation for any child, even if a parent can accommodate him or her, quote, if they consider that to do so would safeguard or promote the child's welfare. And then an important proviso, however, those powers are subject to the ongoing consent of the parent, who may remove the child at any time. And paragraph 27, EF 986, may I highlight the process of removal. If removal from parental care is warranted, the local authority has no power simply to remove the child from parents' care. The local authority must obtain the court's sanction for removal, either by an emergency protection order or a care order. A care order may be applied for by a local authority or an authorised person. Similarly, the court is precluded from placing a child into local authority care pursuant to its inherent jurisdiction. A child can only be in care if the court makes an order. May I now just highlight 1 or 2 aspects of the guidance that social workers are given. And this I can pick up in our printed case at page 14, EF 988. Paragraph 33, we say prior to the coming into force of the 1989 Act, in 1991 the Department of Health issued guidance and regulations in a number of volumes, and we highlight some relevant points under 33.1. The Act, quote, rests on the belief that children are generally best looked after within the family, with both parents playing a full part and without resort to legal proceedings. 2, a care order would only be sought where there appears to be no better way of safeguarding or promoting the welfare of the child. It referred to the duty to promote upbringing by families and to avoid the need for proceedings where possible. Voluntary arrangements through the provision of services to the child and family should always be fully explored. And then under the next paragraph, the top of the page, EF 989, no decision to initiate proceedings should be taken without clear evidence the provision of services for the child and his family, which which may include accommodation under Section 20, has failed or would be likely to fail to meet the child's needs adequately, and there is no suitable person prepared to apply to take over the care of the child under the residence order. And then finally, under Little 4, the local authority should utilise its powers to provide other forms of assistance which may retrieve the situation, and was required to consider this question: what will the use of compulsory powers add in safeguarding the child, and is the gain sufficient to justify use of compulsion and trauma that may result? My Lords, our submission is that social workers have a range of responses to what are generally suboptimal situations. The most drastic and potentially disruptive is taking a child into care. And this is recognised in the guidance which I have just referred to as very much a last resort. And yet most, although not all, but most of these cases have at their core that the local authority should have instituted care proceedings much earlier, thus sparing a child more abuse. My Lords, although we submit that Robinson, Michael, and above all N versus Poole provide clarity in this area of the law.
Sorry, when you say most of these cases, do you mean
Most of the
which cases?
Not these particular cases, but most of the whole cohort of cases involve that allegation. But not every one says that the consequence of alleged failures by the social services should have resulted in earlier being taken into care earlier.
That, in a sense, is the kernel of the case put against you, isn't it? In these cases, that actually what was required was that the social services should have instigated a care order. Yeah.
Yes, that is the argument, or it's slightly different between the two arguments. And what we're saying is that social services have a range of responses short of taking a child into care, which is a difficult decision to make. But on the other hand, the allegations made against the local authorities involve examining what the social services did in response to the particular situation and whether it was negligent.
But of course, if the social services had been aware of the situation that YXA faced, a care order would have been sought.
It's probable that it would have been sought given the extreme facts.
The guidance has to be read
Yes.
on the basis that they are actually aware of the situation before they try to retrieve the situation.
Yes. Unfortunately, social workers will often work in the partial picture of what is going on in a particular household, and they're often, to say taking risks is inappropriate, but they're exercising judgments, bearing in mind that, and that we've concluded in our printed case various dicta, that the law and society tends to favour trying to keep families together or children with those who are related to them rather than taking them to care. That doesn't mean to say they should ignore the obvious, of course, but it isn't a step undergone lightly.
If one were ever to imagine that the safety first policy was to take all children into care, a moment's thought would indicate that that carries its own risks.
Indeed.
Besides being completely impractical and unethical.
Yes, indeed. And borrowing a bit from Strasbourg jurisprudence, one would expect there would be claims on the basis that the rights of the individual under Article 8, for example, were being violated by taking acts. But the important thing is, of course, that my Lord seems quite right. If the information is available in some cases, it looks a pretty clear case. Very often, these cases are not that clear, and the information may not be accurate, reliable, witnesses may be in short supply, people don't tell the truth, and parents may, regardless of the fact, want to keep the child, and the child may want to stay in the family, however, as I say, suboptimal the situation may be. I was saying that it's recognised very much as a last resort, but the claim for most of these cases is that they should have been taken into care. We say that Robinson, Michael, and Poole provide clarity, but my Lord the President, in his judgment in Poole, with whom all the other justices agreed, including some with extensive family law experience, left open the possibility of a claim where social workers assumed responsibility. And it is through that route that the respondents say you should not strike out these claims because a court may decide, when the facts are investigated further, that there was some act or even omission which amounted to an assumption of responsibility. The term assumption of responsibility, or voluntary assumption of responsibility, is now well established in case law, but we submit its exact meaning and scope can be somewhat elusive. It is perhaps understandable that Lord Justice Baker, a judge with vast experience in family cases, but perhaps not familiar with the assumption of responsibility's role in the law of tort, it's understandable that he might have recoiled a little from a submission that the local authority does not assume responsibility towards a particular claimant. Lord, in the case of X and Y versus Hounslow, the Court of Appeal concluded that where a social services department was simply exercising its statutory powers, there would not be a duty. There needed to be, quotes, something more, end quotes. This phrase was picked up and relied upon by Mrs. Justice Lambert in DFX. Our submission is that it will be rare for there to be an assumption of responsibility in the context of social workers simply doing the very difficult job that Parliament has given them. On the respondent's case, it's difficult to see in what circumstances a local authority does not owe a duty of care, or at least might arguably do so, when the facts are teased out. Their case is that a social worker should be considered a professional and that their performance can be analysed in Bolam terms. With respect, this submission appears to ignore a considerable amount of case law. X and Bedfordshire, where this argument was rejected, Stovin and Wise, Orange, Michael, Robinson, and of course, N versus Poole. The alternative argument is that on these assumed facts, i.e. the particular facts of these cases, arguably there is a duty based on assumption of responsibility. The implication is that these cases are highly unusual. I'm sorry to say that that unfortunately is not the case. And also, the court would have noticed that the claimant's lawyers had considerable difficulty in pleading these cases. For example, there were 49 allegations of negligence in YXA. That was not through lack of skill on their part. Counsel has a great deal of experience in this area. It seems that the style was to plead the whole history of social services involvement with a claimant and hope that something in the history will be deemed to be an assumption of responsibility. When we look at the authorities, I can show the court passages where the pleadings are considered. It's our submission that the difficulty in pleading the case is caused by the difficulty of extracting something more from an often long and complex history. The Court of Appeal were critical of the claimant's approach to pleading, but to be fair, it's consistent with the respondent's case. And if it's right, it's a recipe we submit for complete lack of coherence in the law. Where would the respondent's approach leave the law? Cases would have to go to trial. There would be expense, delay, and diversion of resources would follow. And of particular importance, how is the trial judge supposed to determine what is or is not an assumption of responsibility? The argument that what a social worker does can be compared with that of a doctor or other profession does not, we submit, withstand scrutiny. The Bolam test will be particularly difficult to apply. Social workers operate in a far from perfect world where there are rarely simple solutions, and where there will inevitably often be an element of unpredictability. A judge, presumably helped by experts, will have to place himself or herself in the position of a social worker and, while avoiding hindsight, decide whether there was Bolam negligence on the basis of what a hypothetically reasonable standard of care was. And that is to say nothing of the difficulties caused by causation and quantum arguments. In particular, as I indicated, the usual argument is based on the avoidance of damage by taking into care. It might be said that this is comparable to the failure to perform a timely caesarean or to administer antibiotics in the case of meningitis. But such arguments assume that a particular approach would have avoided the damage. Taking a child into care, generally a last resort, does not necessarily represent an assured improvement. The consequences of being in care are too well known to need elaboration, notwithstanding high standard of care that is usually given to children by social workers, partly because by the time they are taken into care, there may be aspects of their character and background which present particular challenges. Our submission is that there is some analogy with the position of the police. Generally, no duty is owed by the police in the context of investigation of crime, but the courts have not ruled out an assumption of responsibility. There's a case called A versus Informer, which is a good illustration of that, and I will take the court briefly to that, where, as the name would suggest, an informer was taken in, as it were, to the care of the police in order to assist them root out a particular criminal gang. But generally, the authorities establish that there will not be a duty of care. It may be different if the police actually cause damage. For the most part, claims have historically been advanced on the basis that the police are responsible in law for the acts of third parties. The law, we submit, is clear that there is no duty in these circumstances. Likewise, we submit, social workers are not liable for failing to protect children from abuse perpetrated by third parties. There are, my lords, a number of other ways.
Well, in a sense, that's why we get to assumption of responsibility, isn't it? I mean, if the starting point is that these are situations where there is a duty needed of care to step in to prevent harm by third parties, the legal response to that is, well, that's exceptional, but one of the exceptions is where there is an assumption of responsibility. Isn't that how we get into the whole problem in the first place?
Indeed, and that's the issue for the court as to whether and in what circumstances there might be an assumption of responsibility. And our submission is that because of the way that social workers operate, pursuant to a statutory scheme and guidance, whilst one should never rule these things out, it will be very rare for there to be an assumption of responsibility. For the most part, social workers are doing their best in the circumstances, using the various tools that they have available to them. My lords, there are a number of other ways in which social workers, we say, are not like doctors or other professionals. First of all, Parliament has given them closely defined powers and duties and provides guidance as to how these powers are to be exercised. Whether and when you take a child into care is very much the subject of developing views. The literature on the subject and recent reports, if anything, suggests that more and more should be done to keep children within some sort of family arrangement rather than taking them into care. But there will no doubt be changes of view depending on the age of the child or particular circumstances. But it's not an easy thing to pin down as to what exactly the appropriate standard is. We refer to Baroness Hale's comments in our printed case. The intervention of social workers also may not be welcomed by a child or his parents, or not by the parents alone. The essence of social work is working together, whether that means a family or with other agencies who may be involved. But interventions by social workers require the consent of those with parental responsibility, And that, of course, includes accommodation under Section 20, which is relevant to the YXA case. Care proceedings are different, but can only be initiated by a local authority. But, my lords, the ultimate decision will be by a court. A care order may be opposed by parents and or the child, who may have a guardian ad litem. And I suppose a judge at first instance may have to decide, if care proceedings had been initiated, whether in fact the child would have been taken into care. It's our submission that in many ways a local authority in its social services capacity has much more of a regulatory role, as pointed out by Lord Brown-Wilkinson in X, and more generally by Lord Toulson in Michael. Also, at this stage, I should refer to some authorities. I will, Your Lordships, be relieved, try to be selective. We have the advantage of a review of the main authorities in N versus Poole. And so, for example, I will not, at the moment, take the court to Stoven and Wise or Gorringe, very important though those cases are, on the basis that Lord Hoffman's observations and the ratio of both those cases have been explicitly approved by this court. The statutory framework is set out in more detail than the passages that I took your Lordships to in our printed case and in a number of authorities. As Lord Brown-Wilkinson observed in X, the question of whether a duty will be owed is profoundly influenced by the relevant statutory framework. There is a useful summary in Lord Justice Baker's judgment in the Court of Appeal of the statutory material, but it is set out in a number of the judgments, and I don't think I need go through it further at this stage. I should offer the Court an apology for the length of our printed case. The mitigation is that there were two cases, and there has, as I said earlier, been a great deal of judicial activity in this sphere, and I will endeavour to repeat, not to repeat what is in our case, but we do, of course, rely on it, and it is indeed a central part of the case before this court. May I take the court now to the case of N and another versus Poole Borough Council, which is at EF 1595, and it is tab 15 of the primary volume of authorities. Well, it's at 1595, the head note explains that the two claimants, both children, one of whom was a child in need within Section 17, and their mother, were placed by the defendant under its powers as the local housing authority in a property owned by a third party, and they were subjected to significant harassment and abuse by a neighbouring family. The claimant brought proceedings against the defendants for damages and negligence, alleging that they had suffered physical and psychological damages as a result of the defendant breaching its common law duty of care to protect them from harassment. It wasn't a claim for breach of statutory duty, but the common law duty of care asserted by them was said to derive from the defendant's duty under Section 17 of the 1989 Act to safeguard and promote the welfare of children, and Section 47 to inquire as to whether action should be taken if it had reasonable cause to suspect. And the claimant said that they would have been moved, or should have been moved, if those powers had been exercised. The claim was dismissed by a unanimous court, and the holding was that a public authority would owe a common law duty of care in circumstances where the principles applicable to private individuals would impose such a duty, unless such a duty of care would be inconsistent with, and was therefore excluded by, the legislation from which the public authority's powers or duties were derived. That a public authority did not owe a duty of care at common law merely because it had statutory powers or duties, even if by exercising its statutory functions it could prevent a person from suffering harm. That therefore a public authority could come under a common law duty to protect from harm in circumstances where the principles applicable to private individuals or bodies would impose such a duty, as, for example, when the public authority had created a source of danger or had assumed responsibility to protect the claimant from harm, unless the imposition of duty will be inconsistent with the relevant legislation. In the present case, the particulars of the claim do not provide the basis for concluding the defendant has assumed responsibility to protect the claimants from harm, since neither the defendant's function under the 1989 Act nor the alleged behaviour entailed such an assumption of responsibility. So the claim was correctly struck out. Can I take the court to page 1609? And my Lord the President was dealing at paragraph 25 of his judgment under the heading Recent Developments in the Law of Negligence. It is accepted that the provisions of the 1989 Act, which impose duties on local authorities, do not create a statutory cause of action. And then my Lord states the question and concludes that paragraph, as will become apparent, the period has been marked by shifting approaches by the highest court. In its recent case law, this court has attempted to establish a clearer framework. As we explained in Robinson, public authorities other than the Crown were traditionally understood to be subject to the same general principles of the law of tort at common law as private individuals. That position might be altered by statute by imposing duties whose breach gave rise to a statutory liability in tort towards private individuals, or by excluding liability for conduct which would otherwise be tortious at common law. I take the court on to paragraph 31 at EF 1611. There was a review of the development of the law after Annes and the London Borough of Merton, a decision which was reversed by Murphy and Brentford. Well, my Lord begins at 31. Although the decision in Annes was departed from in Murphy and Brentford District Council, its reasoning in relation to the liability of public authorities remained influential until Stowin and Wise, where a majority of House of Lords reasserted the importance of the distinction in the law of negligence between harming the claimant and failing to confer a benefit on him or her, typically by protecting him or her from harm. The distinction between policy and operations was also rejected. The resultant position, as explained by Lord Hoffman in a speech with which other members of the majority agreed, was that, quote, in the case of positive acts, therefore, the liability of a public authority in tort is in principle the same as that of a private person, but may be restricted by its statutory powers and duties. And Lord Hoffman is quoted, if such a duty does not give rise to a private right to sue for breach, it would be unusual if it nevertheless gave rise to a duty of care at common law, which made the public authority liable to pay compensation for foreseeable loss caused by the duty not being performed. Further clarification was provided by the decision in Gorringe, and in a speech which the other members of the Appellate Committee agreed, Lord Hoffman reiterated at paragraph 17 the importance of the distinction between causing harm and failing to protect harm in the context of a highway authority's alleged duty of care. It is not sufficient that it might reasonably have foreseen that in the absence of such warnings, some road users might injure themselves or others. Reasonable foreseeability of physical injury is the standard criterion for determining the duty of care owed by people who undertake an activity which carries a risk of injury to others. But it's insufficient to justify the imposition of liability upon someone who simply does nothing, who neither creates the risk nor undertakes to do anything to avert it. And he also emphasised, as my Lord said, the difficulty in finding a statutory duty or power generated a common law duty of care. And, quote, difficult to imagine a case in which a common law duty can be founded simply on the failure, however irrational, provides some benefit which a public authority has power or a public law duty to provide. Lord Hoffman distinguished again, as my Lord pointed out, between a situation where public authorities had actually done acts or entered into relationships or undertaken responsibilities which give rise to a common law duty of care. And then made the reference to a doctor under the National Health Service, where it was said the duty in such a case rests upon solid orthodox common law foundation. And the question is not whether it is created by the statute, but whether the terms of the statute, for example, requiring a particular thing to be done or conferring a discretion, are sufficient to exclude it. My Lord observed that the significance of Stoughton and Wise didn't immediately seem to have been appreciated because it wasn't cited in Van Colley, which also included another case called Smith and Sussex. Confusion also persisted concerning the effect of Caparo until clarification was provided in Michael and Robinson. The long shadow cast by Anne's and the misunderstanding of Caparo have to be borne in mind when considering the reasoning of the decisions concerned with the liabilities of public authorities and negligence, which date from the intervening period. Although the decisions themselves are generally consistent with the principles explained in Gorringe and later cases and can be rationalised on that basis, their reasoning has in some cases and to varying degrees been superseded by those later developments. Can I take, and I don't mean to suggest that other parts of the judgment are not important, but I just want to highlight one or two parts. If I could go to page 1619 at paragraph 56. He was discussing the case of D and East Berkshire. The Court of Appeal's reasoning effectively knocked away the public policy objection to liability. It did not, however, undermine some other aspects of the reasoning in X Miners versus Bedfordshire. It remained the position that where a decision under challenge was taken in the exercise of statutory discretion, it was necessary to establish the decision fell outside the ambit of the discretion, was not therefore authorised by Parliament. It also remained necessary in circumstances where a duty of care depended on an assumption of responsibility to establish there had been an assumption of responsibility and the duty contended for fell within its scope. My Lords, at page EF 1620, paragraph 60, my Lord the President dealt with the case of Mitchell and Glasgow about responsibility for third parties, and then referred at 61 to the case of Michael, which was about the response to an emergency call by the police, which he said, my submission entirely correctly, followed the approach in Stoughton and Gorringe and Mitchell, deciding there was no duty of care unless there was an assumption of responsibility towards the claimant to protect her. And paragraph 63, most recently the decision in this court in 2018 in Robinson, drew together several strands in the previous case law. The case concerned whether the police officers owed a duty to take reasonable care for the safety of an elderly pedestrian when they attempted to arrest a suspect who was standing beside her and was likely to attempt escape. I will come to that case, but having analysed it, the decision was by the court that a duty was owed and there was a breach of duty, although some of the judges seemed a little unhappy about the conclusion they felt compelled to reach. But as my Lord concludes just above letter D, it did not lay down a general rule that for reasons of public policy the police could never owe a duty of care to members of the public. Quite so. It did not lay down any new principle of law, but three matters were clarified. First, the decision explained, as Michael had previously done, that Caparo did not impose a universal tripartite test for the assumption of a duty, existence of a duty of care, but recommended an incremental approach to novel situations based on the use of established categories of liability as guides by analogy to the existence and scope of a duty of care in cases which fall outside them. Secondly, the decision reaffirmed the significance of the distinction between harming the claimant and failing to protect. And thirdly, the decision confirmed, following Michael and numerous older authorities, that public authorities are generally subject to the same, under the same general principles of the law of negligence as private individuals, except to the extent the legislation requires a departure from those principles. And therefore it follows, my Lord said at 65, that public authorities may owe a duty of care in circumstances where the principles applicable to private individuals would impose such a duty unless such a duty would be inconsistent with and is therefore excluded by the legislation from which their powers or duties are derived. The public authorities do not owe a duty of care at common law merely because they have statutory powers or duties, even if by exercising their statutory function they could prevent a person from suffering harm. Public authorities can come under a common law duty to protect from harm in circumstances where the principles apply to private individuals or bodies would impose such a duty as, for example, where the authority has created the source of danger or has assumed the responsibility to protect the claimant from harm, unless that would be inconsistent. Well, I think that I can move on to paragraph 74, 1625, because there my Lord the President was considering Exton Bedfordshire. And Exton Bedfordshire, although in the passage I read earlier, was still considered to be good law in some respects. But part of Lord Brown-Wilkinson's analysis was what one might call a policy analysis. And I think policy has become less fashionable in terms of the analysis. At 74, in the light of the cases which I've discussed, the decision in Exton and Bedfordshire can no longer be regarded as good law insofar as it ruled out on grounds of public policy the possibility that duty of care might be owed by local authorities or their staff towards children. Because in fact, there was a distinction in the two cases in Exton and Bedfordshire. One of them, there was a failure to take into care when there were obvious signs of neglect and abuse. Well, that was the allegation. And the other was when the child was taken into care as a result of a mistake, a case of mistaken identity. That was the Newham case. Both were said to involve the same public policy considerations in there not being a duty of care.
Yeah, this is another example of the sort of the hangover from Anne's, you know, because Anne's creates effectively a prima facie duty of care whenever there's a foreseeable risk of harm, which can only be rebutted on public policy grounds. And so courts in cases like Bedfordshire and Hill were driven to public policy arguments as the only way of stemming the tide of liability.
I respectfully agree. In fact, in Hill, they decided on two grounds. One was proximity, and one was on fair, just, and reasonable. Fair, just, and reasonable was part of the test, reasonable foreseeability, proximity, and then fair, just, and reasonable. But Your Lordship, with respect, is entirely right. The hangover from Anne's was still there. Indeed, the case of Murphy, concerned with building inspectors, was perhaps considered by some who argued the cases to be very much about the responsibilities of building inspectors and couldn't be taken further. So, my Lord...
presumably you say, do you, in relation to paragraph 74, that Exton and Bedfordshire is, as a decision, good law and directly supports your arguments in this case?
We do, albeit that, as I hope I've been fairly pointed out, the fact that the part of the analysis...
the reasoning's defective, but the decision is correct.
Yes. There are, of course, quite a number of other reasons he gives in his very lengthy judgment, and it's the only substantial judgment in Exton and Bedfordshire, consistently referring to the statutory framework and the influence the statutory framework has and the circumstances in which there may or may not be a duty. But the policy considerations were, in a sense, well, if you put that aside in any event, there are strong policy reasons why there should not be a duty.
I haven't reread Paul, but my recollection is that there was an aspect of the Bedfordshire decision which we disagreed with.
Yes, that is true. And I think this was mainly...
Bedfordshire covered a variety of different situations, and I think one of them was it to do with there was positive action taken by the local authority which had harmed the child.
Yes, I think what one was talking about is the fact that Exton and Bedfordshire concerned two cases, one where they didn't do anything and one where they did something, and they were both treated the same by the court, and it's arguable that one might have resulted in a different decision if there hadn't been the policy grounds. I think that was the area that the court was unhappy with.
Yes, that's that. One was I'm just speaking off the cuff. It wasn't one of them a wrongful removal, and the other one was a wrongful failure to remove.
That's exactly right.
And we took, and both were knocked out because public policy says you can never recover against the local authority. And we felt that, in fact, the wrongful removal case shouldn't have been dismissed quite as summarily as that, because that's a positive intervention by the local authority, which, if undertaken negligently, could, in principle, give rise to liability.
Yes, that was the distinction, and also the width of the application of policy not so relevant as it was at the time that Exton Bedfordshire 28 years ago was decided. And I think a theme emerges from all these cases about if the local authority causes damage, then that is different from not conferring a benefit on the local authority, on the child.
But in relation to what we're concerned with, the failure to remove, you say that's good law.
Yes.
Yeah.
And indeed, that was, if one looks, I'm not going to take your lordships to it, but D and East Berkshire, in the Court of Appeal, even who are probably the high point in some ways of the claimant's case or the respondent's case, said that the core proposition that there won't be any duty in respect of failure to take into care remained good law, notwithstanding the advent of the Human Rights Act. And D and East Berkshire has a number of cases were decided when perhaps the courts were still working out the effect of the Human Rights Act on this area of the law. And Lord Phillips, MR, as he then was, concluded that the Exton Bedfordshire couldn't survive the Human Rights Act. That is no longer good law. In a number of cases, it's been decided that you analyse the two separately. For example, Van Colley. And so to that extent, that remains probably an unhelpful or inappropriate comment. Those cases, D and East Berkshire, were all to do with removing children where they thought they were being abused by the family in one form or another.
I see that the difference between the two cases in Bedfordshire is explained at paragraph 38.
Yes. Yes, that's correct. In fact, your lordship would say they were radically different from one another.
Yeah.
In fact, I think the decision in Newham was taken on the basis that Gary was supposed to be the abuser, but the wrong Gary was identified.
That's right, yes. Yeah.
I was inviting your lordship's attention to 1625 in the present case and referred to Exton Bedfordshire and policy. Just above letter F, whether a local authority or its employees owe a duty of care depends on the application, the setting of the general principles most recently clarified in Robinson. Following that approach, it's helpful to consider in the first place whether the case is one in which the defendant is alleged to have harmed the claimant or one in which the defendant is alleged to have failed to provide a benefit to the claimant, for example, by protecting him from harm, and the present case falls into the latter category. At paragraph 78, page 1627, the claim against the council is based instead on an assumption of responsibility or special relationship. And then there was a sequence of events. We see just above letter C, referred to as a chronology of events. In relation to investigation and monitoring by the Council Social Services Department, it refers to the assignment of social workers to the claimants, to the various assessments of their needs, and so on. At 79, Irwin LJ rejected the contention there was an assumption of responsibility by the council on the ground that there was insufficient basis to satisfy the approach of the Court of Appeal in X and Y versus Hounslow and Derby. I have also, said the President, come to the conclusion that the particulars of claim do not provide a basis on which an assumption of responsibility might be established. And then Lordship gave the reasons, including referring to Barrett and Enfield, a case we do need to look at, I think. And I think I probably don't need to go over all the judgment, but clearly we rely on this analysis as being a clear statement of the law, bringing together a number of authorities in a way that made it possible for judges below, short of the Court of Appeal, to apply the law. And of course, whatever else this court decides, I think those who operate in this sphere would very much welcome clarity as to what the law is and where there is likely to be an assumption of responsibility, if that is still to be the law. And may I take the court now to a case called X and Y versus Hounslow, which I've already mentioned once or twice. It's at EF 1928. And it's tab 21 of the primary volume of authorities. The claimant, husband and wife, lived in a 9th floor flat in a council-owned block of flats with the wife's 2 children aged 8 and 11. Both claimants had learning difficulties, as did the older child, and were under the supervision of social workers from sections within the council's social services department dealing with persons with learning difficulties. One social worker gave advice and assistance to the claimants in managing their lives and accompanied them to appointments. I think it's fair to say there was quite a lot of social services involvement in this rather unsatisfactory situation. They were then assaulted and abused sexually by youths who took advantage of their vulnerability and sued. The judge found they were liable, that the duty of care was owed, and damages were awarded in an agreed sum. The Court of Appeal allowed the appeal against the judge's decision and said in the head note that whether a common law duty of care was owed by a public authority to protect another from the deliberate wrongdoing or criminal actions of a third party depended upon the existence of a situation in which the law readily understood that the authority had a responsibility to take care to protect the other from the risk. The authority would not be held to have assumed such a duty merely by doing what a statute required or by acting under its statutory powers, unless it had actually carried out acts or entered into relationships or undertaken specific responsibilities giving rise to the duty. And it was only in such a case that it was fair, just and reasonable to hold the authority owed a duty. The instant case was not one in which the council had control over the claimants, and the word control is perhaps interesting, nor had it created or increased the risk to them, nor was it a case of assumption of responsibility, unless it could properly be held there was a voluntary assumption of responsibility. That the circumstances showed the council's social services and housing departments were seeking to carry out their statutory duties and no more. And no one had assumed a relevant and specific responsibility for the claimant's safety. They went on to find that if anybody had it, it was a particular social worker who they didn't think actually had done anything wrong, or at least nothing actionable. There's only one passage I want to take the court to in the judgment of the Master of the Rolls, Sir Anthony Clark, which is at 1948. The court was applying the case of Mitchell, amongst others, and at paragraph 63, Sir Anthony Clark said, in their written submissions on the decision in the Mitchell case, counsel submit that this case falls squarely within Lord Brown's example of a case where the defendant assumes specific responsibility for the claimant's safety. In summary, they submit that by October 2000, the council had recognised the real danger that X and Y were in, recognised the extreme vulnerability, and the children recognised they could not be protected, and they needed to be moved, had taken steps to achieve a move, and knew they were relying on the council to achieve such a move. It submitted those factors, gave rise to a duty. The assumption of responsibility is put in this way. There was an existing involvement, and there usually is an existing involvement in these cases of social services. an assumption of responsibility in that the council had assumed the task of providing social support for both X and Y, providing suitable and safe housing. In addition, they'd assumed responsibility for rehousing the claimants and the children in the emergency situation that arose. They'd taken a number of steps to do so, but ultimately failed because of lack of coordination. And it was further submitted that they involved a family with known vulnerability and mental health problems who could only live in the community if supported by the council. They were in a position where the council had become specifically involved in its plight in a particular situation of danger, had assumed responsibility and was taking steps to attempt to deal with the situation. There was a heavy degree of reliance by vulnerable adults who were known to be unable to report to the police or resist the exploitation of the gang of youths. And what they said importantly, or what Sir Anthony said, was, we are not persuaded that those considerations lead to the conclusion that there was an assumption of responsibility or some other special factor which might give rise to the imposition of a duty of care owed to the claimants. It appears to us that the principal difficulty facing the claimants is that their essential complaint is that the council was not exercising its statutory powers, duties and powers properly, which the cases show is not sufficient to give rise to a duty of care. Something more is required. Yet both the Social Services Department, through those who are identified, and the Housing Department were simply trying to exercise their statutory functions, no more and no less. We submit that's a very succinct analysis of the position. Well, may I know, my lords, may I take the court to the case of Michael, which is at tab 14 of the primary volume, and at 1540. This was a decision in 2015, a 7-judge court. And I think I can summarise the case, which was effectively that the police had failed adequately to respond to an emergency call. And the question was whether, having been alerted to the possibility of danger, they owed a duty to intervene earlier and thereby avoid the disaster that occurred. There was a division of opinion in the 7-judge court, Baroness Hale and Lord Kerr dissenting, but the duty of the police, as the holding says, for the preservation of the peace was owed to members of the public at large and did not involve the kind of close or special relationship necessary for the imposition of a private law duty of care. And it did not follow from the setting up of a protective system from public resources that it failed to achieve its purpose through organisational defects or the fault on the part of an individual. The public at large should bear the additional burden of compensating a victim for harm caused by the actions of a third party, for whose behaviour the state was not responsible, and that to impose such a duty, which could not be rationally confined, would be contrary to the ordinary principles of common law. It distinguished Dorset Yacht. May I take the courts to 1568? Sorry, before that, 1562, my lords. At paragraph 69, there is then a reference to A versus an informer, which is a case that I mentioned earlier in my submissions. What Lord Toulson says there is, an informer versus a chief constable provides an example of a duty of care arising from an assumption of responsibility, coupled with reliance by the claimant. The claimant contacted the police regarding the activities of a business associate. He was introduced to 2 police contact handlers. He agreed to act as an informant under the police instructions and later signed a set of instructions prepared by the police. At the outset, they explained the steps which they would take to protect his identity and gave him assurances they would treat his safety and that of his family as a priority. As the investigation developed, the claimant himself became a suspect. A restraint order was made under the proceeds of crime prohibiting from disposing of his assets. The Crown prosecution eventually decided not to prosecute him, and the restraint order was discharged. He sued the police, suggesting they owed him a duty of care to protect his economic interests. police conceded they owed a duty of care to protect his physical well-being and that of his family. They had assured him they would do so, and he'd acted on the faith of their assurances. But they had given him no assurances that it would protect his economic interests, and the Court of Appeal upheld the judge's decision that they owed him no such duty, which would potentially conflict with their responsibility to the public for the investigation of crime and proceeds of crime. It is in the vulnerable authorities, but that is a succinct analysis of what the court decided. Now I take the court on to 1568, where Lord Toulson at paragraph 97 is answering the question, did the police owe a duty of care to Ms. Michael on receiving her 999 call? Paragraph 97, English law does not, as a general rule, impose liability on a defendant for injury or damage to the person or property of a claimant caused by the conduct of a third party. The fundamental reason is that the common law generally does not impose liability for pure omissions. It's one thing to require a person who embarks on action which may harm others to exercise care. It's another matter to hold a person liable in danger for failing to prevent harm caused by someone else. The rule is not absolute. The first is where D was in a position of control, that word again, over T, and should have foreseen the likelihood of T causing damage to somebody in close proximity. If D failed to take reasonable care in the exercise of control. Dorset Yacht is the classic example. And your lordships may remember the case of the Borstal boys at Brownsea Island who damaged the yachts. Set close limits to the liability. As Tipping J explained in Couch, this type of case requires careful analysis of two special relationships, the relationship between D and T and the relationship between D and C. I would not wish to comment on the formulation or establishing the special relationship without further argument. Unnecessary to do so, since Ms. Michael's murder was not under the control of the police, and therefore there is no question of liability under this exception. And this is an important passage. The second general exception applies where D assumes a positive responsibility to safeguard C under the Headley-Byrne principle, as explained by Lord Gough in Spring and Guardian. That was the case of the negligent reference. It is not a new principle. It embraces the relationships in which a duty to take positive action typically arises: contract, fiduciary relationships, employer and employee, school and pupil, health professional and patient. The list is not exhaustive. The principle is the basis for the claimant's main submission, to which I will come, that there has sometimes been a tendency for courts to use the expression assumption of responsibility, when in truth the responsibility has been imposed by the court rather than assumed by D. And Lord Toulson said it should not be expanded artificially. In his speech also at paragraph 110, his Lordship considered Stobin and Wise and Gorringe, going on to 111 and 112, and also referred to ex-minors. And this forms part of the head note. At paragraph 113, page 1572, when talking of the services, this time of the police, but we say, one could read across this, which are not peculiarly governmental in their nature. It's a feature of our system of government that many areas of life are subject to forms of state-controlled licensing, regulation, inspection, intervention and assistance, aimed at protecting the general public from physical or economic harm caused by the activities of other members of society, or sometimes from natural disasters, licensing of firearms, regulation of financial services, inspection of restaurants, factories and children's nurseries, and enforcement of building regulations are random examples. He didn't attempt a comprehensive list. But then importantly, he says this: it does not follow from the setting up of a protective system from public resources that if it fails to achieve its purpose through organisational defects or fault on the part of an individual, the public at large should bear the additional burden of compensating a victim for harm caused by the actions of a third party for whose behaviour the state is not responsible. To impose such a duty would be contrary to the ordinary principles of common law. And then he referred to the various cases where the courts had refused to impose a private law duty. Well, was the final case in the trilogy, which we say makes up the law, and which was certainly considered to be the law by the lower courts until the Court of Appeal is the case of Robinson.
So is, I mean, do you take Lord Toulson at para 115? We're putting to one side control as irrelevant in our case, I'm assuming. We're solely concerned with assumption of responsibility as the principle. He seems to be saying in 115 that assumption of responsibility requires a representation and reliance.
Your Lordship has pinpointed one aspect which is important, which is the question of reliance. It has been held in a number of cases that there is no doctrine of general reliance. That was an argument which was disposed of by Lord Hoffman, so that, for example, we may all hope that an ambulance will turn up on time. We may hope to be rescued by the Coast Guard if we find ourselves in difficulties at sea. But those bodies don't owe us a duty of care. We don't rely on them in the sense of reliance generally is used in an assumption of responsibility. And it's our submission here that although children, parents might have hopes that social services will intervene, they might also hope they won't intervene. But there is no question of reliance in the way that it is normally understood in assumption of responsibility.
Reliance in relation to children is a very, very difficult concept because, for a start, they may be too young to expressly rely. And as you say, they may not like the approach taken by social services, but who else are they to rely upon to protect them, even despite their wishes and feelings being contrary to the approach adopted by social services? So the concept of reliance is very, very hard to apply in relation to children.
I absolutely accept that. Of course, when the children get a little bit older, there might be a greater degree of reliance. Their views will be expressed, and of course, their views in litigation are often expressed through the guardian ad litem, insofar as they're ascertainable. But children may often have all sorts of conflicting and different views, and it is difficult to analyse it in terms of reliance.
Yes.
I said that I would come to Robinson, which is at tab 17, 1690. This was a case of police officers trying to arrest a suspected drug dealer. A struggle took place, and three men knocked into a frail old lady, aged 76. They were trying to arrest her, and she was injured and sued. And the judge decided there was negligence in the ordinary way, and that there was a duty owed. And the court held that the police generally owed a duty of care in accordance with ordinary principles, the law of negligence, unless statute or the common law provided otherwise. And there was no general rule that they were not under such a duty of care when discharging their functions of preventing and investigating crime. Applying those principles, the police might be under a duty of care to protect an individual from a danger of injury, which they themselves have created. But in the absence of circumstances such an assumption of responsibility, they were not normally under a duty where they had not created the danger. So that's orthodoxy, we submit. The appeal was allowed on the basis, on the present case, this was a positive act by the police and not an omission. And since there was a reasonably foreseeable risk of injury from arrest if a suspect were attempted in a busy shopping street in a town centre, the police officer had owed a duty of care towards pedestrians, including the claimant in the immediate vicinity when the arrest had been attempted. Of course, it's obvious that the police owe a duty to exercise reasonable care when, for example, driving a police car, in the same way that we all have a duty of care towards other motorists when we drive a car. The judgment of Lord Reid at my Lord the President can be found at 1702 when he deals with public authorities in general. In particular, paragraph 31, when he reiterates the fact that there is a return to orthodoxy via Stovin and Wise and Gorringe. And then generally, he says at 32, public authorities are subject to the same liabilities in tort. Accordingly, paragraph 33, if conduct would be tortious if committed by a private person, it's generally equally tortious if committed by a public authority. See Dorset Yacht. It's explained in Gorringe's case. That principle is subject to the possibility that common law may provide other, or statute provide otherwise. And paragraph 34, on the other hand, public authorities, like private individuals and bodies, are generally under no duty of care to prevent the occurrence of harm, as Lord Toulson stated in Michael's case. And then my Lord refers, not for the first time, to an an article written by Tafaris and Steele. Also, my Lord, the President referred to in his speech in N versus Poole. And we have it in the academic bundle of academic material. As that summary makes clear, there are certain circumstances in which public authorities, and like private individuals and bodies, can come under a duty of care to prevent the occurrence of harm. See, for example, Barrett and Enfield and Phelps. Those two cases which are relied on by my learned friend, as explained in Gorringe. In the absence of such circumstances, however, public authorities generally owe no duty of care towards individuals to confer a benefit upon them by protecting them from harm. Smith and Littlewoods and also Mitchell. So, my Lords, that was the position in law when the cases which you're concerned came before courts. I said that I would go to one other main quote, but I think I can probably do that later. That's the case of Barrett and Enfield, on which much reliance is placed. The decision in HA...
I do apologise, but is your position really that the law is absolutely clear in N. Poole? Yes. And one need say no more about it than that?
Well, in a sense, yes. We do say it's a complex area, but we say applying N, which in itself embraced Michael, Robinson, Stoven and Wise and Gorringe, the law is essentially clear. And I hope to make that submission good by the next case I'm going to take you to, which shows how the courts actually applied it. Because what's, of course, important is that the guidance of this court is capable of application by judges hearing these cases, whether they're on striking out or at trial. I'm not going to spend a lot of time on the judgments below, but as I said earlier, they are excellent judgments we would submit, and they do bear careful examination. The key documents bundle contains them, which we can find the first decision by Deputy Master Baggett, QC, as he was then, page EF 98. And there's the passage I want to take you to is at page 122, where paragraph 31, what the Master is doing is commenting on attempts that were being made to distinguish the facts of the YXA case from Poole. And he said this: the features relied upon in the first example also arose in Poole, but one of the children was placed on the Child Protection Register, and there was Section 47 investigations into allegations of significant harm. There is nothing which places this in a different category from what went before, such as carrying out assessments and having meetings with partner organisations. I agree with the observation made that it is a distinction without a difference in the circumstances. It is no more a service provided for the children than it was in the Poole case. That is not a factual circumstance which can give rise to an assumption of responsibility.
Sorry, which page are you on?
This is at page 122, EF page 122, and it's paragraph 31 of his judgment. And then over the page at 123, the assertion that consideration being given to apply for a care order must amount to an assumption of responsibility does beg the question, why? It's difficult to see how taking advice from a legal officer in the council changes the way in which the council is holding itself out in terms of child protection. It is not a significant further step, especially given there is no allegation that any proceedings were issued. Again, I do not accept this as a factual circumstances which can arguably give rise to an assumption of responsibility. If child protection plan had been drawn up and implemented as in Poole, but no duty arises, it's difficult to see how this was changed by saying that some advice is going to be given. There is no allegation that inappropriate advice was given. It's simply an allegation of omission. This is not an assumption. This does not amount to an assumption of responsibility. And then he says this, importantly, although there are, as there always would be, even between closely analogous cases, some factual elements present in the history which differ from Poole, it does not involve the factual undertaking of responsibility being taken. And at paragraph 33, a duty of care is recognised to arise when a care order is made because the local authority has parental responsibility. But up until that point, parental responsibility remains unequivocally with the parents. A duty of care cannot, in my view, be reverse engineered from the point at which a duty arises on the making of a care order in the way that the first claimant would wish. That reverse engineering metaphor was actually picked up with approval by Mrs. Justice Lambert in her decision. This involves saying that because the duty arrives on the making up of the order, so there is a duty to conduct any care proceedings brought competently, and so there is a duty to decide whether to institute care proceedings competently. Therefore, there is a duty to investigate competently to decide whether to bring care proceedings. The attempt to trace back a duty at an earlier and earlier stage does not provide a viable route to an arguable case. At EF 593, we have the decision of Master Dagnall in YXA. Although there are many references to Exon Bedfordshire, Michael, Robinson and Poole, as you'd expect, I think I can take this quite shortly and go to page 631. Well, it starts just at the bottom of 630, paragraph 73, a discussion and analysis, he having referred to all the leading cases. He held to be as follows, during in particular from the paragraphs cited above at Poole, there is at least no conclusive reason, public policy or legislative provision against a local authority owing a duty of care in relation to the child care functions. It's clear that the rulings in Exon Bedfordshire to that effect are no longer the case. Thus it is possible for a local authority to owe a duty of care, but that must be established by the application of ordinary common law principles. And those common law principles provide no duty will arise simply to confirm a benefit, including by way of protection from harm. This is notwithstanding the relevant public body may have a statutory role and rights which are designed to enable it to protect the claimant from harm, whether for fire brigade, police, children from abusers. However, a duty of care can arise in four categories of case: assumption of responsibility, done something which prevents another from protecting B from danger and has a special level of control over that source of danger, or A's status creates an obligation to protect B from the danger. An assumption of responsibility can arise from the performance of statutory functions and or the provision of services to a person, e.g. the unconscious stranger, who does not realise that those services are being provided or that they are in relationship with the defendant. Thus, if services are provided, including the provision of care or accommodation, then generally duty of care will arise in relation to the provision of those circumstances, as in Barrett and Enfield. Although it'll be our submission that Barrett and Enfield needs to be revisited to some extent, although I'm not inviting the court to overrule a decision of the House of Lords, but I will come to that.
I think in that context, I think the discussion in Poole of the provision of services related to things like education, health, picking up from the Bedfordshire case, where if a public body is providing services such as teaching or educational psychology or surgery for that matter, then a duty of care arises on ordinary principles.
Yes, that's quite correct, because of course the National Health Service has a statutory background, but the relationship between doctor and patient or any other health worker is perfectly capable of analysis on ordinary private law principles. There's nothing about the statute doesn't, as it were, get in the way of that relationship. It is by way of background. The case of Phelps was a case of an educational psychologist who was said not to have diagnosed dyslexia or identified dyslexia in a child at school. Initially, the judge found that there had been a failure and that there was a duty. The Court of Appeal decided that that was wrong, that first of all, they reversed the decision on facts and decided that actually the duty was not owed to the individual, Pamela Phelps, because the local authority sought the advice of the educational psychologists for their benefit rather than the claimant's benefit. The House of Lords reversed that decision and decided, rather on the lines of the NHS, that actually you could analyse what an educational psychologist did vis-à-vis an individual, rather in the way that you'd analyse a doctor-patient relationship, and that the statute did not mean that there was therefore no possibility of a duty. What followed from Phelps and London Borough of Hillingdon were quite a few cases, but that litigation has rather fizzled out. They involved cases of bad teaching and failing to spot weaknesses in pupils. In America, they don't have any of these claims are allowed, but the law still exists. Phelps hasn't been expressly overruled, but it has been rather confined in terms of its application.
It would be helpful at some stage, I think, for you to pin down examples of where you accept that there is an assumption of responsibility, because you're giving us lots of quotes of the judges accepting that there can be an assumption of responsibility. It would help me to know what you regard, therefore, as satisfying the assumption of responsibility test.
My Lord, we certainly scratched our heads and tried to think of an answer to that question. I'm reluctant to commit myself because our basic submission is very unusual or rare. We think for social workers going about their business with this range of activities to step outside the normal scope of the statutory powers exercised thereof, so as to give rise to something more. When I come to consider Barrett, there was a decision there which, I say, needs to be looked at in context. Essentially was that when a child is actually in care, you can distinguish that from a child who is in the community, albeit with social services involvement in what they were doing. And therefore, there might arguably be a duty, because by taking someone into care, you had assumed responsibility towards the claimant. I think whilst a child is, as it were, in the community, not in care, it is very difficult to foresee circumstances. But some social worker might, as it were, almost be on a frolic of their own and undertake some particular activity which wasn't, as it were, statutory in nature. That might give rise to a duty of care. If a social worker is driving somebody or doing something quite ordinary, then there might be a duty. But in general terms, I'm a little reluctant to answer my Lord's question, because it's difficult to envisage, we think, a case where social workers, just as they said at X and Y, going about their normal jobs, would assume a responsibility. And we invite the court in due course to say that, whilst never ruling it out, just as there's no exclusion by the courts of the police in appropriate circumstances assuming responsibility, it will be rare, particularly when the danger against which they are said to be acting is to protect from the acts of a third party. It's not causing direct damage.
Well, I don't know what you're going to tell us about Barrett. On the face of it, you might have thought that that would be a situation of an assumption of responsibility. And I suppose one might add, and I don't know what you'd say about this, but in YXA, during the period at which the child was in the foster care, would the local authority not there be said to have assumed responsibility for that period of time?
Well, that is the argument that the learned friends advance. Section 20 of the 1989 Act provides for accommodation to be provided, respite care, it's sometimes referred to, from time to time if the local authority thinks it's appropriate. But at all times, it must be with the consent of the parents. And so this is a voluntary cooperative relationship where a family may need some respite because they're having to deal with in the case of the second claimant, a very troubled individual who was proving too much for them to manage. That doesn't assume a duty in the statutory sense, but it is more likely that if there is close control over where somebody lives or how they travel, then there might be a duty owed on ordinary principles. I think in view of what my lords asked me about Barrett, it would be useful if I looked at Barrett now before moving on to what Mrs. Justice Stacey concluded.
I thought it had been conceded that if a child was taken into accommodation under Section 20, that there would be an assumption of responsibility for the care whilst in that accommodation. First of all, was that conceded?
We didn't. I don't think we conceded anything very specifically, but I would concede now that if, for example, the accommodation was unsafe, or and damage was caused to the individual, or something about kind of ordinary negligence took place in that context, it is more likely that a duty would arise where social services have control where somebody lives than if they don't. But it doesn't mean that ipso facto that generates an assumption of responsibility.
You're conflating breach, that is, if the premises are unsafe, with the duty. The duty is to provide safe accommodation and to accommodate safely. The question of whether there's a breach depends upon whether the premises are unsafe.
It does, of course, ultimately depend on that. But on the other hand, the allegation in this case is that there's no allegation made in respect of the premises themselves or anything unsuitable. The allegation is that at the end of the term, voluntarily housing the child should not have been sent back home. That's the point about reverse engineering. So that if it had arisen whilst in the physical care of the local authority, it is more likely that there would have been an assumption of responsibility. Although it does beg the question, assumption of responsibility for what? And its extent.
That was what I thought you had already conceded, assumption of responsibility for actually caring for the child whilst in accommodation. And
yes, I'm grateful. My learned junior, Mr. Stagg, reminds me of paragraph 123 of our printed case. We say it's accepted that it may be arguable that WCC owed YXA a duty of care when placing him with foster carers for the periods of respite care to take reasonable care to ensure the household in which he was placed was safe for him. And then it refers to a case called Blewett. So to that extent, I accept what my lord says, but of course it's important to consider the scope of any duty or assumption of responsibility and what's an assumption.
That's what M. Fool says.
Yes, absolutely. But I did refer a number of times to Barrett and Enfield, and it might be convenient if I looked at that now. It's at tab 4 of the main authorities bundle, and it's at 1180. This is a decision of the House of Lords reached in 1999, and it was about a plaintiff who was placed in the care of the defendant local authority when he was 10 months old and remained there until 17, so really almost all his life in care. And the claim that he brought against the Enfield Borough Council was based on a duty said to be owed to him, that duty being that expected of a responsible parent to protect him from physical, emotional, psychiatric or psychological injury. And in particular, it was said they failed to arrange for his adoption or provide him with appropriate and properly monitored placements, a failure to obtain appropriate psychiatric treatments, etc. And the appeal was allowed, and this came, of course, after X and Bedfordshire, on the basis that it would not be fair, just and reasonable to impose a common law duty of care on a local authority when deciding whether or not to take action in respect of a case of suspected child abuse, did not have the same force once the child was already in local authority care. Of course, we were still looking at policy in those days. In all the clearest cases, it was important to see on the facts proved whether what was alleged was justiciable. The plaintiff's case was far from clear, and moreover, in addition to the question of whether it was fair, just and reasonable, duty care was not to be decided in the abstract on the basis of hypothetical facts, and so the claimant was entitled to a trial. It's fair to say that the court did not, in fact, entirely speak with one voice on this. Slightly different ways of analysing it. Lord Brown-Wilkinson gave the first judgment. He, of course, had given the main judgment in X and Bedfordshire shortly before. And he did draw a distinction, although the Court of Appeal had felt that this case was entirely decided by the House of Lords in X and Bedfordshire. But he disagreed with that. And if we come to what he says at 557, just below letter B, I find it impossible to say that all careless acts or omissions of a local authority in relation to a child in its care are not actionable. Indeed, I do not read the Court of Appeal to so have held. If certain careless conduct operational of a local authority is actionable and certain conduct policy is not, we were still on policy and operational then, it becomes necessary to divide the decisions of the local authority between those which are policy and those which are operational. I point that out because this analysis was using terminology which is no longer perhaps in vogue. Moreover, he says just below D, there have been two developments since the conclusion in the present case, both of which have been drawn to the attention by the parties. Rather than reading it, I perhaps can explain what those two developments were. The Bedfordshire case concerned not only claims against local authorities in their social services capacity, but conjoined with that appeal before the House of Lords were claims against local education authorities. And during the course of his comments on the education cases, he thought that the psychology service, which would normally be provided to identify dyslexia, might be open to the public. And what he said was at the bottom of the page, as the Court of Appeal rightly held in Phelps' case, those remarks were based on a mistaken assumption that psychology service would be a service open to the public. The Court of Appeal, ironically, the Court of Appeal's decision was then reversed by the House of Lords, but at that stage said, actually, the education authority which provides psychologists, isn't owing a duty to the public because it's for the local educational authority. But clearly, what that influenced Lord Brown-Wilkinson in saying, this isn't really a case for a strikeout because we need to know the full facts and it's unsafe to strike it out. And the second reason, which also casts a long shadow over this area of the law and indeed on the striking out generally, he refers to at 1188, which is the case of Osman, which would be well known to the court. He says at 1188 about Osman, I confess I find the decision of the Strasbourg court extremely difficult to understand. But his interpretation of the passage which he quotes is discussed at 1189, just below letter A. The passage seems to treat the Osmans as having a right under English law to go to court for a declaration that apart from the public policy preventing suits against the police, they would not have had a claim in negligence against the police, and further that it was not fair, just and reasonable in the circumstances of that case to apply the exclusionary rule, i.e. the rule excluding negligence actions against the police. And then moving on to 1190, just below the top of the page, in view of the decision in Osman case, it's now difficult to foretell what would be the result in the present case if we were to uphold the striking out. It seems to me that it is at least probable the matter would then be taken to Strasbourg. That court applying its decision in Osman case, if it considers it to be correct, would say that we deprive the plaintiff of his right to have the balance struck between the hardship suffered by him and the damage to be done in the public interest in the present case if an order were to be made against the defendant's counsel, Kenton Council. In fact, of course, in Z versus the UK, which was X at the European Court of Human Rights level, the European Court of Human Rights decided that it perhaps had misunderstood English law and that striking out was really properly to be considered more by way of a preliminary point and didn't deny the claimant his right to a fair trial under Article 6. But it's important that this was the understanding of the House of Lords, and perhaps it's an additional and obvious reason as to why there was a reluctance to strike out at this particular stage.
The way we dealt with this case in Poole was rather different. We focused on the speeches of Lord Slynn and Lord Hutton.
Yes.
And Lord Hutton, with which two of the other members of the committee agreed. And Lord Hutton, I think, in terms, says that taking the child into care means an assumption of responsibility, entails that. And I think Lord Slynn relied on also an assumption of responsibility resulting from taking the child into care, and drew an analogy with the analysis in Bedfordshire of where a school had been said to, a local authority school had been said to assume responsibility for the care of pupils by taking them as pupils.
Yes, that's right. And I was going to come to what Lord Slynn said briefly in a moment, and indeed what Lord Hutton said.
Just taking up my Lord's point, if you apply N. Poole, there are two bases. We assume responsibility because we've decided to be the child's parent, and we know that the child will rely upon us as a parent. Or the second way of approaching it is we'll provide a service as a parent in the same way as a school provides a service. So both
Yes.
of those would fall within Poole.
The difficulty with that analysis is that actually Lord Hutton rejects the comparison between parent and child, because I think partly because the law has generally set its face against children being able to sue their parents, so that the comparison doesn't really work.
That was the exact point that I was going to make. That is that you started this by saying that the duty was the duty of a parent, which is a sort of paternalistic approach, whereas it's the duty of reasonable care, yes. Isn't it?
It's different in kind. Well, that's what Lord Hutton thought. Lord Slynn did not think that it was appropriate to strike it out. He reviewed a lot of the authorities, and I think it may be useful to fasten on 1198, middle of the page. He's gone into the Bedfordshire reasons, the excellent Bedfordshire reasons. He says, whilst not casting doubt on the validity of these factors in the context of the investigations or the steps which it was said should have been taken in those cases of child abuse and neglect of educational needs, it does not seem to me that necessarily have the same force separately or cumulatively in the present case. Thus, although once a child is in care, there may be cooperation between social welfare bodies, the responsibility is the local authority and its social and other professional staff. Pausing there, one of the arguments was, well, very often these are multi-agency decisions, and therefore it's odd if you single out one part of that multi-agency response as being owing a duty. The decision to remove the child from its home has already taken the authority as statutory powers in relation to the child, which do not necessarily involve the kind of distinction involved in taking a child from its family into care. So he was distinguishing that. He also referred to Lord Reed's judgment in Dorset Yacht, and I think the Dorset Yacht cases and indeed the Parkhurst prison cases are examples where the court has been much more persuadable that a duty is owed in tort where the relevant defendant or public authority exercises control over somebody, and clearly the Borstal boys, these should have been under the control of the Borstal officers, and a prisoner should be under the control of the prison. We would be submitting that it's not precisely analogous to the situation of a child in care.
I'm not sure the control principle has got any relevance here at all, has it?
Well,
we're talking in Dorset Yacht about control over third parties who then cause harm to the claimant. We're not in this scenario, surely.
It's very different, but the reliance was placed by Lord Slynn on Dorset Yacht. We submit that my Lord's right, that he's rather different, because here was the Borstal boys who actually caused the damage. What we're talking about here is third parties who caused the damage rather than the defendants.
I mean, there's no question of the local authority having a duty of care because in some sense they've got control over the parents here.
Yes.
It's the parents who are causing the harm.
Yeah. The relevant control has to be over the source of the danger.
Yes, that's true. And the only relevance of control, it's a slippery word, is the context in which there may or may not be an assumption of responsibility. And if there has been assumed a responsibility to control the third party from causing damage, which we say is not the case, that is the question that the court has to ask.
Yes, I just want to be clear that I don't think it's been put against you that there's any question of control in the principles that have been laid out by the courts to overcome the problems of failures to benefit and omissions. One of them is control, but that's not in place, as I understood it. In this case, we're purely concerned with whether there's an assumption of responsibility.
Yes, of course, when there is an assumption of responsibility, it may be because the local authority, and this may be the argument against me, has assumed some sort of control over the life of the individual. Control, I agree, has different applications in different contexts in the law and tort.
As I say, I think that's control over something different than what the control of the danger is what we're talking about. Yeah.
Yes, it's used quite often, as I've endeavoured to point out in the authorities, and never been precisely defined. What Lord Hutton says at page 1206 is that at this early stage, which can be regarded only to the particulars of claims and medical reports, the weightiest complaint appears to be the defendant failed to place him for adoption, which resulted through the years of his childhood and youth having no settled home, but in moving about. He claims this, he was disturbed and unsettled life caused the damage. And then, in answer to my Lord Stevens, the question of what sort of duty, if any, is owed by the local authority, he deals with at 1217 at the foot of the page. Having discussed the cases about claims against parents, and in particular a case called Surtees and Kingston upon Thames, I do not agree with great respect to these are the public policy considerations as to why you shouldn't be able to sue your parents, but because the law should not permit a child to sue his parents, the law should not permit a child to sue a local authority who is under a duty by statute to take him into care and to make arrangements for his future. I consider the comparison between a parent and a local authority is not an apt one in the present case, because the local authority has to make decisions of a nature which a parent with whom a child is living in a normal family relationship does not have to make. For example, whether the child should be placed for adoption or placed with foster parents, or whether a child should remain with foster parents or be placed in a residential home. He goes on to discuss the fact they have trained staff, etc. So the analogy is not perfect. Although it is passing noting that he too refers to Osman at page 384. So it was clearly an influential factor in the analysis. It's important we submit to say about Barrett that it was a decision not to strike out. A distinction was certainly drawn between a duty that might be owed, and I emphasise the word might be owed, to a child taken into care and one who had not been. The judgments don't give any help as to the scope of any such duty. It may mean, we submit, that like anyone else, the local authority will be liable in some circumstances when they're doing something fairly ordinary, but which is capable of analysis in ordinary Donahue and Stevens terms, but is not something, as it were, that is statutory or derived from statutory powers or guidance. So what is unclear from this case is what sort of duty, on what circumstances there will be an assumption of responsibility. We respectfully submit that the idea that, as it were, once a child is in care, he or she is then suddenly in a safe place is somewhat, I think, contentious submission, and that it will be difficult often to say whether a child is better off in care or not in care. We essentially submit that Barrett doesn't decide the circumstances in which a duty of care might arise when a child is in care. It also should be regarded as a case of its time, when Osmond was very much in vogue or was a concern, when policy and operational still remained in vogue, and where fair, just and reasonable and policy appeared also to be throwing a considerable influence on the thinking of judges. Well, having made a detour via Barrett and Enfield, I was going to take the court to the first instance decision, only briefly, of Master Dagnall at EF 593. He sets out in considerable detail the relevant statutory provisions and refers to, I'm looking at 74, to X and Hounslow. He refers to Michael and Chief Constable of South Wales Police, and Robinson at page 75. And then at 77 refers to N versus Poole, which considered all those decisions, and quotes at considerable length from my Lord's judgment, and then comes to his conclusions as to what the state of the law is at page 631 and 632. Perhaps there's one passage which might be useful in view of the questions that I've been posed, which is at page 97.
Sorry, you seem to be jumping between two.
I'm so sorry. It's 633. I should forgive me. It's EF 633, paragraph 78. Fourthly, as to whether reliance in terms of dependence upon of the claimant upon the local authority is sufficient to found an assumption of responsibility. Again, I think Mr. Levinson puts this too highly. It's correct that an assumption of responsibility may arise in circumstances where one person is clearly relying upon the other, at least where that other accepts, whether consciously or not, that reliance. However, dependence, at least in the context of this case, is a different matter. The fact that one person, here the claimant, depends upon, in the sense of needs because they have no other recourse, and another, the defendant, to assist or save, then does not mean of itself that the other has any duty to do so, even if the assistance or salvation is within their power to effect. To hold that was the case, which seems to me to be directly contradictory to N and Poole and the case law, which holds there must be more to give rise to a duty to protect from another harm. I think I can leave Master Dagnall and to go to DFX and Coventry, which is at EF 1293. This was the case which was decided in 2021 by Mrs. Justice Lambert, and it's very unusual in the sense that this was a case which actually went to trial, so we can see how these cases actually work out when they're run. If one looks at page 1293, the court can see that the claimants lived with their parents and siblings in Coventry which was responsible for the provision of social services, child welfare and child protection. And between 1995 and 2010, the Social Services Department was involved with the family. Unfortunately, it's quite often the case that there will be a long-standing involvement of the Social Services Department. This was one of those. Unfortunately, they suffered sexual abuse and neglect prior to their removal. It's alleged they've been abused by their father, and there are effects alleged abuse by the farmer and a family friend. Both parents had learning disabilities, and the claimant's father had been convicted of offences of indecency. The holding dismissing the claims that at common law public authorities were generally subject to the same liabilities and tort as private individuals, therefore under a duty of care. And then it does say exceptions to this general rule may arise where there was an assumption of responsibility to protect an individual from a certain harm, or where something has been done to prevent another from protecting an individual from the source of danger, or where there is a special level of control over the source of the danger. So control does come into that part of the judgment, or where the status of the individual or body created an obligation to protect an individual from that danger. And it was held that this claim arose from alleged failure to confer a benefit. It was not suggested that any direct act performed by the council caused harm to the claimants. The omission was of a failure to exercise a statutory function and commence proceedings which would have led to the claimant's removal from the family home. This in itself did not mean the duty of care could not exist. It did not follow that a failure to exercise could never be compensable by law. Whether there was a duty of care generated by an assumption depended upon whether there was something more, that's the expression coming from X and Y again, either something intrinsic to the nature of the statutory function itself, or something about the manner in which the defendant had conducted itself. This was fact sensitive. In this case, it was not reasonably foreseeable that the claimants would rely upon the council, such as to give rise to a duty of care, and there was no positive act which had the effect of generating one. There was nothing in the nature of the statutory function being exercised that gave rise to a duty of care. She also found there was no breach. And the judgment does indeed bear considerable study. But at 1331, she summarises the legal principles, relying upon Lord Toulson and Lord Reid, my Lord Reid, gives an impeccable summary we submit there and over the page, including...
Sorry, could you give me the page number again?
I'm sorry, it's 1331.
Thank you.
And 1332. And at 1333, she takes head on the question of assumption of responsibility and the decision in Poole. Lord Reid concluded in Robinson, properly analysed, did not involve a failure to confirm a benefit. Mrs. Robinson's injuries were inflicted by the police officers themselves. You remember that is the case where there was an arrest in a crowded area. The risk of harm was not only foreseeable, reasonably foreseeable, but actually foreseen by the police officers. This was sufficient to impose on police officers a duty of care towards pedestrians in the immediate vicinity of the arrest. Liability in Michael and Poole was, however, analysed by reference to assumption of responsibility. Lord Toulson concluded that what had been said to the call handler could not give rise to an assumption of responsibility. The handler had given no assurance to the caller other than that she would pass on the call. Having concluded that the facts in Poole consisted of a failure to provide benefit, the question for the court was whether the defendant had assumed responsibility to protect the claimants from danger. And she then continued the analysis. And she then analysed this case. And the high point appeared, for the claimant's point of view, was the obtaining of a particular report called the Rayside Report, which was alleged to be an assumption of responsibility. She deals with the assumption of responsibility on the facts at 1340, paragraphs 201. And in deciding that there was no duty arising from this, she says at the top of 1341, I take into account that for the purpose of considering whether such a duty has arisen, it will be sufficient if viewed objectively. It would be reasonably foreseeable that the claimants would rely upon the defendant discharging its functions with reasonable skill and care. But as Ms. Roger and Ms. Schofield, these were expert social worker witnesses, confirmed, the local authority's assessment of risk may not be shared by the parents nor the children, Had proceedings been commenced, the parents would have been separately represented and the children's interests represented by a guardian ad litem. It would not necessarily follow that the local authority's viewpoint would be aligned with that of the family, children or parents. In these circumstances, I do not accept it to be reasonably foreseeable the claimants would rely upon the defendant to give rise to such a duty of care. And then she says at paragraph 205, internal 1341, like Law Reid in Poole, I see nothing about the nature of the statutory function which the defendant was exercising which gave rise to a duty of care. The counsel has not pointed me in the direction of anything which was said or done by the defendant in the context of obtaining the Rayside report or in the context of decisions made which involves assuming or undertaking an assumption of responsibility. And then she does consider expressly at 1342, paragraphs 28, the cases of Phelps or Barrett, and does not accept at the end of paragraph 28 the reverse engineering analogy drawn by Deputy Master Baggett. And then paragraph 209, 1342, she concludes, therefore, on the facts of this claim, no duty of care was owed by the defendant to the claimants. I've considered whether there was anything in the nature of a statutory function or the manner of those functions were exercised which generated a duty of care. Having done so, I find nothing which suggests to me the defendant had assumed responsibility to exercise those functions with reasonable skill and care. Having looked for something more, as I put it, I find nothing. And she concludes that the defendants were, quote, merely operating a statutory scheme, what contrary to the now well-established principle set out in Stovin and Gorringe. I mention DFX at this juncture because Mrs. Justice Stacey, as well as having the careful analysis of the law formed by the Deputy Master and the Master, had in fact seen the DFX decision, which enabled her to read and analyse it. And the decision of Mrs. Justice Stacey is at EF 643, tab 4 of the key documents. She dismissed the appeal from the Master's decision in both of these cases. And we can see at page 649, EF 649, that she quotes extensively from the judgment of Mrs. Justice Lambert. She says at paragraph 24, DFX Mrs. Justice Lambert conducted...
Can I just interrupt for a moment? I just wonder if it might be possible, perhaps over the adjournment, to obtain a better quality of copy of this judgment for us. Whether it's printed or electronic, it's not easy to read.
I think it can be found at 136, which will be a better copy, I hope. EF 136.
No, well, not in a hard copy, but possibly electronically.
I think it's electronically EF 136.
Yeah, that's it.
Yes, that is easier, thank you.
YXA core documents.
Oh, that's much better. Yes.
Well, I'm sorry, I think there has been a certain amount of duplication with two cases and similar things, these things.
Well, it's worked in our favour on this occasion.
I was saying that there is a very considerable quotation from Mrs. Justice Lambert referring to the trilogy of cases.
Which paragraph?
This is paragraph 24 of her judgment, and it's page EF 142.
Yes.
Yes.
The analysis and discussion, which is paragraph 63, is at EF 155. paragraph 63, she begins her analysis, which in my submission is entirely consistent with what all the judges said below and what Mrs. Justice Lambert said. Perhaps, and she too takes up the idea that there should be something else, and said in paragraph 67, a resolving of her judgment, resolving to seek legal advice and undertake a full assessment is not sufficient to amount to that extra something. And then at paragraph 68 of her judgment, the defendant's decision, Mr. Levinson considered the defendant's decision to undertake keeping safe work with HXA and then not doing it to be his best point. Particulars of claim do not suggest that if keeping safe work had been done, the claimant would have been able to protect herself and be safe from harm from Mr. A and her mother, but rather it was alleged that if keeping safe work had been done, care proceedings would have resulted. So firstly, the allegation is expressly framed as an omission, failure to confer the benefit by not doing the keeping safe work, not an allegation of a positive act that amounted to an assumption of responsibility. Secondly, on a proper analysis, as with the other two matters, the criticism was the failure to institute care proceedings, and therefore was indistinguishable from the reasoning in Poole and DFX, and fails for the same reason. As noted in DFX, even if a duty of care was generated by direct work, the scope of that duty would be limited to the performing of the direct work competently. It does not amount to the necessary somewhere else. A number of questions are involved. It requires a careful analysis of exactly what is the responsibility the defendant said to have assumed, i.e., assumption of responsibility doesn't exist in the air. Each of those would involve fundamental problems for HSA to overcome. And in paragraph 69 of her judgment, in YXA, it's important to distinguish between the duty of care, which arguably arises after the making of a care order, when the local authority becomes a statutory parent, and the entirely different position of a child, albeit a looked-after child, such as YXA receiving temporary and intermittent care under Section 20 with the consent of the child's parents, where the parents retain exclusive parental responsibility. Important to stress they do retain exclusive responsibility. There was no criticism of the standard of care received by YXA during the intermittent periods of his temporary accommodation, which could give rise to a potential claim. Instead, the claim was advanced, as it was in HXA, on the basis of an alleged duty of care, which, if properly discharged, would involve the taking of care proceedings. It is now well established that there is no duty of care owed in relation to child protection functions generally, and the fact of a Section 20 temporary accommodation cannot be used as a peg on which to assert the assumption of responsibility. Now, the imprecise duty in Section 22(3) cannot support a duty of care when none would otherwise exist. There is no logical reason why the provision of Section 20 would make a difference. It does not amount to something else needed to indicate an assumption of responsibility to take care. Proceedings, merely an assumption of responsibility for duty of care in relation to the accommodation itself. And then there was the burning building, which I don't think we need to take the matter any further. And then paragraph 72 of her judgment, she says, the Supreme Court has now clarified the approach to be taken to ascertain whether a duty of care is owed in its judgments of Michael, Robinson and Poole. The facts alleged in these two appeals are on point and so closely analogous to the recent Supreme Court judgments and now DFX at first sight cannot be described as a developing area of law, as noted by Deputy Master Baggett. And she concluded at the end of paragraph 74 that she agreed with my learned friend Mr. Stagg's submission, as the last sentence, that post-Poole and DFX, the assumption of responsibility by a local authority so as to give rise to a duty of care to remove children from their families and child protections is not a developing but a settled matter of law. So the Court of Appeal in this case had all those decisions, and of course they were advanced in the lower courts. May I now come to the Court of Appeal's judgment, which is at EF 86.
So one of your central submissions is that this was all being worked out perfectly straightforwardly in the lower courts,
Yes.
applying N and Poole.
Yes. My Lord, yes. I should say it's the head note is at EF 53. The holding, and I'll come to the relevant passage in the judgment. Lord Justice Baker gave the only judgment, allowing the appeals, and the head note deals with what the relevant allegations were. That the circumstances in which a local authority might assume responsibility for a child so as to give rise to a duty of care were not limited to cases where it had acquired parental responsibility and the Children Act. But whether a local authority had assumed responsibility for a child so as to give rise to a duty of care would depend upon the facts of the case, which would include the specific requirement under statute, regulations, or guidance in force at the time. But that since this was still an evolving area of the law, it was not yet clear where precisely the line was to be drawn between those cases where there had been an assumption of responsibility and those where there had not. And that in the first case, the actions of a local authority in resolving, one, to seek legal advice with a view to initiating care proceedings and to carry out a full assessment in respect to the claimant, and two, take specific action designed to protect the claimant, namely arranging for keeping safe work to be carried out, were both capable of amounting to an assumption of responsibility. That in the second case, the actions of a local authority in providing accommodation for the claimant under Section 20 were capable of amounting to an assumption of responsibility, which was not necessarily confined to the actual periods when he was being accommodated, and that accordingly, in both cases, the judge had been wrong to strike out the claims and purported to apply N versus Poole. And then per curiam, where a claimant wishes to plead that a local authority assumed responsibility, the particulars claim should identify the facts which are alleged to amount to the assumption of responsibility and the scope and the extent of the alleged duty. Put simply, the claimant must identify clearly and concisely what it is said the defendant had assumed responsibility for and what facts are relied upon as establishing the defendant has assumed that responsibility. The relevant discussion of the law begins at EF 86.
It's a curious way of putting it. Just looking at that, that should identify the facts alleged to amount to the assumption of responsibility. The facts alleged to amount to the assumption of responsibility. Well, I'd say it's something rather that flows from facts, but be that as it may, and the scope and extent of the alleged duty. So the assumption of responsibility is something distinct from the scope of the duty. But then it said you have to identify what the defendant assumed responsibility for. Either one collapses them and says you assume responsibility for the performance of the duty, or you distinguish them conceptually and say you assume responsibility for the safety or whatever it is of the child, and it follows that there is a duty in the factual circumstances to do a particular thing, like apply for a care order, for example. But I'm not sure it's a bit conceptually confused the way it's put there.
I respectfully agree. The discussion and conclusion is at EF 86, and he, and I think this is relevant, and perhaps with respect relevant to what my Lord Regis just said. He considers the particulars of the claim and recites the well-known principle that it should contain a concise statement of the facts upon which the claimants rely. And then says, above letter E, in context, the claimant should therefore identify the facts which are alleged to amount to an assumption of responsibility and the scope and extent of the alleged duty. Put simply, the claimants must identify clearly and concisely what it is said that the defendant has assumed responsibility for and what facts are relied upon in establishing the defendant has assumed that responsibility. In addition, the claimant should identify the dates on which the alleged duty arose and, if relevant, the period or periods during which the duty was owed, and matters said to establish a breach. And he was critical of the fact that in this case, as is quite often the case in these cases, it was a lengthy sequence of events, really going through the whole sequence of events that happened where the local authority was involved to a greater or lesser extent. And he felt it was unhelpful to approach the case on that basis. Paragraph 90 of his judgment, EF 87, he said there is a fundamental difference between the general duty under Section 17.1 of the 1989 Act and the specific duty under Section 22.3. I mentioned early on that he appears must be introducing a new division. Under Section 17.1, every local authority is under a general duty to safeguard and promote the welfare of children within their area. A duty of care cannot arise simply as a result of the local authority's general duties, such as those under Section 17, but may arise as a result of the local authority's exercise of its specific duties to a child on the specific facts of the case. The circumstances amount to an assumption responsibility for the child. To paraphrase Lord Reed, the operation of a statutory scheme does not automatically generate an assumption responsibility, but such an assumption may arise out of the local authority's conduct pursuant to a statutory scheme. Depending on the facts of the case, any assumption responsibility may arise out of the local authority's conduct, where it acquires parental responsibility, Barrett and Enfield, or an interim care order. But in my view, the circumstances in which a duty of care may arise are not confined to such cases. It is correct that a local authority by whom a child is accommodated under Section 20 does not have parental responsibility, unlike an authority who have been granted a care order for a child. But the circumstances in which a local authority may assume responsibility for a child so as to give rise to a duty of care under the law of negligence are not confined to cases where it acquires responsibility under the Children Act. In what other circumstances does the local authority assume responsibility for a specific child so as to give rise to a duty of care? That is a case, Lord Justice Baker says, as a question rather, which can only be answered definitively on a case-by-case by reference to the specific facts of each case. It is not appropriate to lay down guidance in a judgment such as this, where the court is considering appeals against orders striking out claims. I confine myself to observations about the circumstances arising in these two cases. First, the duty of care may arise in respect of looked-after children. Statutory duties owed by a local authority under Section 22 are owed to every child being looked after by the authority, not only children who are in care, but children being provided with accommodation. And then 94, he says, in my judgment, contrary to the view expressed by Master Dagnall, endorsed by Stacey J., this potential responsibility is not necessarily confined to the actual periods where the child is being accommodated. He then goes on, perhaps I can take up your lordships to EF 89 and paragraph 99. We are not, however, required to decide whether or not the claimants in these proceedings will ultimately succeed in establishing that there was a duty of care, let alone whether there was any breach of the duty which caused damage so as to give rise to a claim for compensation. The question for this court is whether the master and the deputy master at first instance and the judge were right to strike out the claims. And quotes again from my lord, the existence of an assumption can be highly dependent on the facts of a particular case. And where there appears to be a real possibility such a case might be made, the court will not decide to strike out. He accepts what my lord said in Robinson and quotes that, where the existence or non-existence of a duty of care has been established, it's unnecessary and inappropriate to reconsider whether the existence of the duty is fair, just and reasonable. I also accept that to proceed by discarding established principles and deciding each case according to what the court may regard as its broader merits will be a recipe for inconsistency and uncertainty, quite so. In my judgment, however, this is still an evolving area of law. The ramifications of the change of direction heralded by the decisions of the Supreme Court in Robinson and Poole are still being worked through. Unusually for child protection cases, the risk of harm to the children in Poole came from outside their family. The risk to the children in the present cases came from within their families. He then adopts Lord Staines's words in Gorringe and Calderdale Metropolitan Council, I should perhaps say this, that Lord Steyne's comments in Gorridge are not normally relied on for a number of reasons. Firstly, his judgment was not endorsed by any of the other judges in that case. Although they all endorsed, Lords Hoffman, Scott, Roger, Brown endorsed each other's judgments, they specifically did not endorse what Lord Steyne said. It must be in any event regarded as obiter. So to hinge the analysis based on that judgment was, in our submission, unsatisfactory. But nevertheless, he quotes it as no single decision is capable of providing a comprehensive analysis. And it remains, as Lord Steyne said, a subject on which an intense focus on the particular facts, on the particular statutory background, seen in the context of the contours of our social welfare state, is necessary. And he said the decision of DFX is just one judgment. 101 EF 90, where a local authority has been involved with the child over a number of years, exercising its statutory duties and powers by providing services to the child in order to safeguard and promote his welfare, identifying where there has been an assumption of responsibility by local authority may be a complex exercise. For those reasons, where the area of the law is still developing, it would be wrong to reach a definitive conclusion and strike out the claim before the evidence has been heard.
The full implication of that is, may I take it from the first sentence, that in any case where a local authority has been involved with a child over a number of years, etc., a claim should not be struck out.
So that all these cases, even if they don't involve children in care or even one temporarily accommodated, we need to look at the facts to decide whether there is a duty of care. What the Court of Appeal don't do is to give any indication of circumstances in which there might be an assumption of responsibility. If they had, I might have been able to deal more readily with the question asked by my Lord Burrows. They don't give any examples of what an assumption of responsibility. The two particular factors here are capable of being an assumption of responsibility, but apparently you can only decide whether there's been an assumption of responsibility if you have a full-scale trial. Although in fact, of course, the claimants are enjoined to plead the case with sufficient precision so that a court knows what is capable or might be capable of being an assumption of responsibility. What he summarises at paragraph 105, EF 91, and says this: to sum up, this is still an evolving area of the law in which will only be through careful and incremental development of principles, through decisions reached after trial, after full trials on the evidence, that it will become clear where precisely the line is to be drawn between those cases where there has been an assumption of responsibility and those where there has not. If the assumption of responsibility were to be confined to cases where a local authority had acquired parental responsibility under a care order, the line would be clear. But in my view, that is not the effect of the decision in Poole. The responsibility for a child required to give rise to a duty of care can be assumed in wider circumstances. Whether a duty arises will always depend on the specific facts of the case. As the reports from the family courts, which of course is very much his area, demonstrate, there is a very wide range of circumstances in which the Social Services Department may become involved in the lives of the children in its area who are at risk of being abused. In many such cases, it may not be possible without a full examination of the facts to establish whether or not a duty of care arose. In due course, he says at 106 EF 91, a body of case law will emerge. It will become easier to identify the circumstances in which an assumption of responsibility can exist so as to give rise to a duty of care. At that point, there will be a greater scope for striking out. But at this relatively early stage in the development of the law, after the Poole case, striking out these claims would, in my view, be a wrong use of the power under CPR Rule 3.4. The question for a court, he's allowed the appeals, he says the question for a court considering an application to strike out a claim to adopt Lord Reed's words is whether the particular claim set on any basis on which an assumption of responsibility might be established at trial. Before this court, the only pleaded matters are those which are particularised. The outcome will be that the appeal will be restored. So one is tempted to observe that on the analysis of the Court of Appeal, the Poole case didn't really decide anything. Because you have to look at the particular facts of every case, and by choosing to quote from my Lord's judgment saying there can be an assumption of responsibility. Lord Justice Baker widens the scope of a potential assumption of responsibility to cover really almost anything that a social worker does or does not do. There is, if this judgment is to be read as representing the law, local authorities can be sued for almost any involvement at any stage, not restricted to being in care, no help as to what the scope of any assumption of responsibility or any scope as to what the precise, or any definition as to precisely what that duty should be.
There's an interesting passage also, paragraph 98, where just below B, he says that even where a duty of care is established, the claim will only succeed when the claimant proves that the local authority was in breach and the breach has caused damage. It's important to emphasise the local authority social workers have a wide discretion, make complex and difficult assessments. A claimant asserting there's been a breach of a duty of care is therefore likely to face a high hurdle. This has perhaps been lost sight of in the cases which are focused on the existence of a duty of care. And he endorses a comment on the Poole case that the case could have been better dealt with on breach and causation grounds. So, so there's obviously scepticism about whether it's worth thinking about whether there's a duty of care at all. Just go straight to the assessment of whether there's a breach.
Well, yes, he seems to be saying that the control mechanism should be breach rather than the existence of a duty.
Yeah.
But that does beg the question, how do you assess whether there's a breach if you haven't defined the nature of the duty in which you've said you're in breach?
It also sucks you into a full trial in every case.
Yes.
And one of the benefits of having a duty analysis is that one has a reasonably determinate marker as to when you need a trial and when you don't need a trial.
Precisely. And in a sense, that's why I respectfully submit that DFX is helpful, because there was a trial and there was an analysis of the law, but there would be endless trials if the Court of Appeal is right.
I think you would say on DFX that the analysis of the law would have been possible at the strikeout stage, because you'd have had the pleaded allegations which then ultimately failed. And if a court can see at the strikeout stage these allegations of in relation to duty are going to fail, the court should grasp at that point.
My Lord, indeed.
Could I ask you one question? That is prompted by my Lord Borough's circumstances in which an assumption of responsibility might arise. And to take an example of a case in which I was involved, namely a child, a Portuguese child of African descent, comes to Northern Ireland with the mother, and then is abandoned in Northern Ireland by the mother. So you have a child in Northern Ireland totally abandoned, and the social services are then involved in caring for that child. At the stage where the social services are aware that no one else is looking after the child, is there an assumption of responsibility?
I'm not, of course, familiar with the statutory scheme which may exist in relation to Northern Ireland. Your Lordship has the better of me that. But assuming it's broadly similar, then what the social services would be doing would be what they would be doing in England and Wales, which is to exercise their powers in accordance with guidance, which may result in a number of different acts taking place to do what they consider is best for the welfare of the child.
But I was looking at the duty arising. Okay? Assume for one moment that they have a duty at that stage. They have assumed responsibility because they know that the child has been abandoned. You then look up to the breach of the duty if they don't do anything. But that is different from the question as to whether the duty of care arises.
Well, Lord,
because they've got plenty of powers. They can apply for a care order, they can apply for emergency protection, they can do all sorts of things. But if they don't do so, has there been a duty as an assumption of responsibility? They have identified a child, they know it's abandoned, and do they at that stage assume responsibility?
The the general duty which exists in English law to look to take care for the welfare of all children within your area. I mean, there is that general duty. So in a way, the local authority becomes a sort of corporate parent to all children within the necessary borough. Most children, of course, they do nothing about. But then there are various steps they can take. They may know that a child, as in the one that my Lord mentions, is in particular being abandoned and particularly vulnerable, and one would expect the local authority to intervene and do what they thought was appropriate. But they'd be doing so, exercising statutory powers. And in doing that, they would not thereby assume responsibility in the way that the expression is used in the law of tort. They would be responsible in the ordinary sense of the word. One would expect them to be responsible. But assumption of responsibility is a very specific term where the courts have developed it. And
well, I agree that that depends upon the extent of the duty which they assume.
Yeah. I mean,
obviously they have statutory duties which arise, but the question is whether, by virtue of making a decision that this child has been abandoned, do they assume a common law duty to take steps?
In my submission, they don't, because the statutory scheme does not ordinarily generate a duty of care. That's clear from the authorities. Notwithstanding the fact that one would expect and hope that the local authority would do their best, that does not translate into there being a duty of care, whether expressed as a duty of care or an assumption of responsibility.
I mean, if you're looking at the model of a private actor, which is what Paul tells us one has to do when you're looking for a duty of care analysis in the common law, one might think that the well-established principle that you don't have an obligation to step into a pool to save a drowning infant might be taken to apply in the sort of situation there. That, as you say, one would hope that the local authority would intervene. It certainly has lots of statutory powers to do so, but its failure to intervene is a failure then to exercise its statutory powers, which seems to be the class of case where there isn't a duty of care.
If it would be under a statutory duty, wouldn't it, under Section 17? It shall be the duty of every local authority. And if they perform that duty, then the effect will be to vest them with parental responsibility.
Well, if one assumes, that assumes, as it were, the consequences of their consideration of their duty would involve, say, taking the child into care, which may well be the case. But in doing so, they were exercising their statutory powers in accordance with the statute. The statute would not normally give rise to a duty of care, as the authorities clearly establish. And the only, as it were, narrow window which the friends have to go through is to say that in these particular circumstances there was something different which can be said to an assumption of responsibility rather than the general exercise of powers which the local authority in England and Wales, or indeed in Northern Ireland, would exercise.
Yes, or it might be, one might fall back on something other than duties of care and tort aren't necessarily the only legal basis for requiring a local authority to intervene. I mean, quite apart from the statute.
But there's a distinction, isn't there, between the local authority seeing the position and doing nothing. And as I understood it, the hypothetical we were being given, or the real case, was the local authority actually intervening. Now, at the point at which they do intervene to look after the child, and I assume at that point take over parental responsibility, at that point, surely there is a common law duty of care because of the assumption of responsibility.
We would submit not, because I think your Lordship is thinking of the second case where the child was accommodated under Section 20 on a temporary basis.
No, I'm not. I was assuming that there is no other entity looking after the child at all in the example given by Lord Stevens. The local authority has decided to take responsibility for the child. Surely at that point there's a common law duty of care.
They haven't decided, with great respect, my Lord. They have a statutory duty
to have regard to the welfare of this child or any other child in the area. It's not a decision. There is no, as it were, bargain between the child and the local authority. This is the exercise of a power by a regulatory agency, which does not normally give rise to a duty of care, much though one would expect and hope that the local authority would respond to a position.
Well, there certainly would be a limited duty of care to actually look after him in the immediate future. So if one's looking for the positive act which assumes responsibility, it may be whatever the factual circumstances were in relation to the decision of the local authority. They've got a statutory duty. There's no cause of action for breach of statutory duty. The question is whether they have assumed responsibility, and that would be fact-dependent.
The authorities have established that if there is no action for breach of statutory duty, it is not normally right to superimpose a common law duty on the statutory framework.
Unless there's an assumption of responsibility.
Unless there's an assumption of responsibility, which begs the question of in what circumstances there would be an assumption of responsibility. And our submission is that those circumstances would be very rare.
There's a case from there is a precedent from about 1800 in a case involving Eastbourne Council, where the Poor Law Commissioners refused to look after a woman and her children. She had married a German who had been in England during the Napoleonic Wars, and he abandoned her. And she took the nationality of her husband under the laws it then stood. And because they weren't English, in consequence, there was no liability under the Poor Law to care for the family. But the judge said something to the effect that the law of humanity, which prevails over all other laws, requires the commissioners to care for this family. So as another approach. If we resume at 2, is that going to be rather too short for you?
No, I think that's...
Okay, then 2 o'clock.